Good morning, everyone. Virgo here. It is June 11th, 2019, and I hope everybody's having a great start to your week. I have been getting a lot of questions with regards to the Sharon Tracy Gale Bay court case. So I'm going to address some of those right now so that this way everybody has a better understanding of how the court procedure in a criminal proceeding works in the state of Pennsylvania. I also am going to address the question that everybody keeps asking by both email and in the comments section, which is it possible that Sharon's actual bail was revoked since no one has seen her post? I have contacted and spoken with the court to determine whether or not that is the case. Sharon's bail was not revoked. And my original thought process was, if it had been revoked, it would have shown on the docket sheet, in which it didn't. But I wanted to make sure, since there were so many people that were asking. Sharon's next trial, actual trial date, is July 15th. So that answers those questions. Let's go over what happens after you are arrested in the state of Pennsylvania, no matter what county that you might be arrested in. This is the same process everywhere in Pennsylvania, and I hope this will help people to better understand what it is that the process actually is there. It appears to be a little bit different than many of the other states. So let's take a look at it. Preliminary arraignment. The first official event in the Pennsylvania criminal justice process is the preliminary arraignment. After a person is arrested for either a misdemeanor or a felony, they will be taken in front of a magistrate at the local district court where they will be arraigned. Arraignment is a process where the magistrate will review your criminal history, work history, and ties to the community to determine what your bail should be set at. Bail is an amount of money that the magistrate believes will secure your future appearance in court if you were released from custody. For example, if a crime is a low-grade misdemeanor like driving under the influence or a DUI, and you have strong ties to the community, it is likely that the magistrate will give you a release on your own recognizance. Or unsecured bail. ROR means that you don't have to post any money in order to secure your release from custody, pending the outcome of your trial. It also means that you would not be required to check in or be monitored by a bail agency. Unsecured bail is different with unsecured bail. While you also don't have to post any money, you would be required to adhere to certain bail conditions, which are set by the magistrate. If you've been charged with a serious offense or felony such as possession with intent to distribute or aggravated assault, something of that nature, the magistrate may require you to actually post money to secure your release from custody. Or, in the extreme cases, the magistrate could deny bail altogether, which means you would be required to remain in custody until the charges are dismissed or until your sentence has been concluded. At your preliminary arraignment, the magistrate will also set a date for your preliminary hearing. Okay, with regards to bail, we know that Sharon actually ended up having to get bailed out. Her bail was set at $50,000 and she was required to pay 10% of that, so $5,000. That bail still stands. Preliminary hearing is what's next. After you've been arrested and charged with a criminal offense and before you can be tried on that offense, there first must be a preliminary hearing in front of the local magistrate. At the preliminary hearing, the Commonwealth Police District Attorney must present evidence to the magistrate that a crime was committed and that by a preponderance of evidence, more likely than not, or 51% at least, you were the person who committed the crime. If the magistrate finds that the Commonwealth has presented sufficient evidence that you committed the crime or you are charged with that you are charged with, then he or she will bind the case over for trial. If the Commonwealth has not met its burden of proof, some or all of the charges could be dismissed. A preliminary hearing is not a trial, so there are limitations on what evidence, if any, a defense attorney could present. Nonetheless, a preliminary hearing is a valuable tool to a defense attorney as it gives them an opportunity to evaluate the evidence against their client and cross-examine the witness or witnesses before the actual trial. In some cases, it may be possible for your lawyer to get the misdemeanor or felony charges reduced to a summary citation offense where you pay a fine and avoid prison or probation. Let me just say that we know at this point that Sharon is representing herself. And we know at this point that no plea deal or dropping of any charges has occurred according to the docket. Formal arraignment. After the preliminary hearing, if the magistrate finds that there is sufficient evidence to hold your case over for trial, he or she will schedule your formal arraignment at the Court of Common Pleas in the county where you were arrested. The formal arraignment is the day your case is transferred from the lower magistrate district court to the trial level court, the Court of Common Pleas. At the formal arraignment, you are advised of certain rights and asked to enter a plea of either guilty or not guilty. Pretrial conference, call of the list. After your formal arraignment, your case may be listed for either a call of the list or pretrial conference. We know that Sharon's was a pretrial conference. Depending on the county of your arrest, both are status conference hearings to advise the judge on what the status of the case is. Here, the judge will be advised on whether a plea deal is in the works, whether the case is immediately proceed to trial, or whether it is necessary for the case to be delayed to discover new evidence. In some counties, it may be possible for your attorney to work out a favorable plea deal at the pretrial conference or the call of the list that would resolve the case without having to go to trial. We do know that the case is definitely going to trial. If a plea deal is not reached at the pretrial conference, which in Sharon's case it was not, or the call of the list, your case will be put on the trial list. When your case is put on the trial list, it is expected that your case will proceed to a full trial and the court will take steps to secure a jury panel to hear your case. At the time of trial, the Commonwealth must prove that you are guilty of the alleged crime beyond a reasonable doubt. A reasonable doubt is a doubt that would cause a reasonable, prudent person to pause or hesitate before making an important decision in their life. You would not be required to present any evidence or to testify, but you have the right to do both if you wish. All 12 jurors would have to agree that you are either guilty or not guilty. Next, we have the sentencing hearing, which is the final, of course, the final end to this. If your case ends with a conviction, either due to guilty plea or a finding of guilt after trial, the next step will be a sentencing hearing. If you have pled guilty, the sentencing hearing can either take place on the day of the plea on a subsequent date. If you were convicted after a trial, the sentencing hearing will usually be held at a later date. At your sentencing hearing at your sentencing hearing, you or your attorney will be permitted to present arguments for the sentence that you feel is warranted based on your criminal offense. Oftentimes, this is your chance to explain why the crime was committed, how you plan on rehabilitating yourself, and apologize for your conduct in hopes that you receive a lighter sentence. Okay, we know at this point that Sharon does not have anyone representing her. She's representing herself. And we know that it's going to trial. We also know for absolute certain that her bail stands as it is right now. And we know that the trial date is on July 15th. That's about all that I can give to you guys in terms of what I can find out right now. And then, of course, I've provided you with the information to take a look at the docket yourself. I don't want you to get confused. There is one area that I've had some questions on, and that is what is a lower court? So from court to court, you've got the lower court is where it actually hits before it goes to trial, is what that is. So just because it says lower court, it doesn't mean lesser court, which I think is where there were a few people that were getting confused about that. It hits the lower court in order for it to go to trial. So it doesn't mean that anything's been dismissed or anything's been lessened in terms of, felony degrees or misdemeanor degrees. It simply is a way for the trial to take place, and it's just what they call it, apparently. I've tried to do some actual looking on that to see whether there was an actual definition, and basically it just kind of takes you in a circle. So but that is what it means in this case. I actually checked that out with the court too. It has to be sent to the lower court in order for it to go to trial. So that is what it means. It doesn't really mean anything else in terms of the degree of seriousness. That is not changing. So I hope this helps everybody. If you've got questions, please put them in the comment section, and I can try to get to them as rapidly as possible. And I'll do the best that I can. I'm going to, at this point, call on the attorneys that are actually in my, that actually visit this channel. When you hear this video, can you kind of look over the comments and answer any possible questions that there might be? Emma, this would be for you. I mean, there's actually several other attorneys that visit this channel a lot, to make sure that if I can't answer a question, it's probably going to be really easy for you guys too. But hopefully this helps everybody and answers some questions for you. I know it's a bit confusing, but we just kind of have to follow it as it stands right now. And thanks so much for listening and taking the time. Bye-bye.